So I teach a deals class, and at the end of it, there were 16 students in it this, I guess, a year ago or so. And the students came up to me at the end of class and said, so we had fun in this class. We think we learned something. We would like to go on a trip. One aspect of my deals class is we go on trips. Right? We actually hold the class every other week at a law firm. That's one of the tropes I use to make it more intriguing for them. And they said, oh, we love these trips. You know, they came with free food and things like that. Let's figure out a competition we can go to. Because all these other folks who are taking trial ad and so forth, they get to go to all these moot courts around the country and around the world. Let's go to ours. And I said, sure. If you find one, I'm happy to talk to Dean into paying for it. And so they went off, and they came back with this thing in Vienna. It was an international arbitration competition. And I said, let's go. Vienna, sure, why not? I think that's a great idea. And my dean said, that's not transactional law. And I said, yeah, but it's in Vienna. He said, okay, that's not transactional law. If that's really what you wanted to do, you're cheating. So what it is you really want some good pastry, right? And I said, yes, I agree. That's what I wanted. I said, so go find one that's really a transactional one. So then we zoned in on the ABA negotiation competition. And lo and behold, that's really a dispute resolution negotiation. And so we kept looking, and we couldn't find a transactional competition unless you want to second yourself to a business school team doing some kind of business plan competition. Now that was possible, and I think Mark could tell us more about that, because I think your folks do that. But from a pure, it's the lawyer's centerpiece kind of a deal competition, there wasn't one. Right? And that shocked me. That's bizarre. Why would that be? I learned why it is. It's really hard to do one. But I said to the students, well, if you're willing, if we build it, they will come, right? So let's build one of our own. And so what I'm here to tell you about is what was the inaugural transactional lawyering meet. And you'll see I use meet because that plays on the word moot. Right? So everyone hates that, including my kids. In any event, it's going to stick because I'm hoping it acquires some longevity as a concept. What was the meet? Well, we wanted to start small, so we decided 10 teams. You'll see I say 12. That's because Columbia and Cornell, the professors there, were not willing to tell the 20 students that wanted to do this that only 2 of them could come. And so we compromised, and they got to send 2 teams. The way I did this, and the way I'm going to do it again, is I went to specific faculty members at each of these schools, and I said, Tina, are you willing to designate 2 people to go be your team from Emory to this competition? Mark, are you willing to designate 2 people? Karl, are you willing to designate 2 people? Because I don't want to have to figure out how you figure out who your team is. We're not there yet. Right? The aspiration, as we'll talk about later, is for schools to develop intramural competitions and ideally regional competitions, just like moot court. But for the time being, I'm going to rely on specific faculty members to figure out how they're going to deal with the fact that, in fact, they're going to be, at least some schools, a outpouring of desire to do this. Cornell says they're going to hold an intramural competition this year, and they already have 20 teams within the school that want to participate for their shot at the big leagues. Right? So this is the list that came. I highlight Georgia and Indiana because they won. Now, how did they win? Because we were too scared to pick between them. As you'll see a little bit of a sample of their performance, they were both extraordinary. And so the judges were unwilling to split pick between them. But every one of these teams did an extraordinary job. I talked about team selection. The only school I'm aware of last year that ran an internal competition, although you'll maybe correct me, was Brigham Young. They actually had a VAC from Skadden, and she ran an event, an actual competition. Actually, she tried out my scoring rubric, which was very helpful to get that kind of feedback. But I think for the most part, people used interviews. They picked people from class performance, however they did it, or they did the Columbia method, which was try to send everyone. I don't recommend that. We won't let that happen again this year. The way the competition worked was each team, once they were selected, was sent a case statement, and I am happy to share a copy of that. I think ultimately it'll get posted on this Tina's website. But this case, and frankly, if your interest is in holding a competition at your own school, I think it'd be a great idea to use last year's statement. That's a great way to start. I think that's what Cornell's going to do. It was the story of Wanderwagon, which is a New York Stock Exchange publicly traded company that is in the recreational vehicle business. They make RVs. They also happen to make modular housing, which was a mistake on their part. They went into that business exactly at the boom. When they went into that business, it caused them a great financial distress. And also they happen to be not doing so well in the RV business given the economy. And so they're facing a financial crisis. They're cash poor. But they have within the RV space a small division that makes folding trailers or camping trailers, which are these things, right? Which are different than RVs. They have a different distribution channel. They have a different customer base. And it's actually the only cash flow positive business they have at the moment. It's reasonably profitable. And they own a 42% market share in this space. And over the transom comes a proposal from Chestnut Hill Capital Partners, which is a private equity firm that, unbeknownst to Wanderwagon, is already buying another business that has a fold-in trailer business in it, and has decided that it wants to also own Wanderwagon's business. And realizing that Wanderwagon needs cash, they go forward with an unsolicited proposal to buy a division. And there's a basic statement of these facts. There's a basic statement of the difficulties that Wanderwagon is in. There's a discussion of some of the warts that will come out in time related to the business. There's a trademark dispute. Wanderwagon does not own the trademark under which it sells its camping trailers. Some other company owns that and is unhappy with them. There's a substantial personal injury claim being brought because one of these wagons got unhitched on Highway 85 and took out everyone behind them. So there's a litigation related to that. And then there's the usual laundry list of things that are going to be issues in an acquisition. Attached to the case statement is a form of due diligence questionnaire that has in fact been responded to. And so the typical due diligence information is available to the students as they get to understand the case. I apologize. I realize I forgot to bring this disc. In addition to getting the case statement, every team, and the teams either represented the buyer, Chestnut Hill, or the seller, Wanderwagon, got a DVD. And on the DVD, they were introduced to the general counsel of Wanderwagon or the MD, the managing director at Chestnut Hill Capital Partners, in an interview. And the interview was done like this. There would be flashed on the screen, and I really apologize, I forgot to bring this because I think it's really good.
And you are the star.
I'm the star. A question gets popped up, and there are 20 or so questions, and they are the typical questions you would imagine would be the basis of an initial meeting between the client and the lawyer. So, how are things going with the deal? That's the first question. And then, lo and behold, this hedge pops up. It's a very low quality, you could do it at home kind of iMovie. It wasn't that hard to do. I used a webcam. I tried to do it in a way that anyone could do so that I didn't have to spend $50,000 on. There was a group here that earlier showed us this $50,000 movie they made. That is the response of this counsel to all these questions. And so not only do you have the common state of facts, but you have the unique state of facts that you got from your discussion, your virtual discussion with your client. And based on those things, your assignment, and each team has this assignment, is to mark up the form of letter of intent and we used letter of intent, not the full-blown acquisition agreement, to constrain the exercise to a reasonable workload. We provided a standard form that everyone worked from so that at least there was some common base, but we did not restrict them in terms of how far afield they could go from the form. We did restrict them in terms of the number of pages they could create. And they were told that after they've had a chance to review the facts, review the interview with the client, and then consider the form, they were allowed to ask their client 20 questions. Okay, and what does that mean? Was that they were each given a chance to send 20 emails to the client. So each team sent 20 emails of exactly what more they needed in order to be able to effectively provide the first markup. Right? And they were given about a month to do this. I was the client in both cases, and I was the answerer, the source of the answers for these 20 questions. I haven't done it yet, but I've started. It's very interesting. I now have 240 questions. I'll tell you, there are only really 30. And once I developed the answer, of course, it was a form. I cut and paste. Right? My dream is, if I do this enough times, I can automate it. Right? It's like a Google word search type driven thing. It was hard the first time. It'll get easier, right? Because these questions are fairly basic, and some of them are really inane. I'm trying to think of the one that I found most funny. It'll come to me. All right. Resources, like an associate and then like the class I teach, there were none. Right? Every student was given the link to the Practical Law Company because they wrote me a check. And also I think it's a pretty decent place to start. There was a small bibliography that was provided to treatises, form documents, and so forth. But the idea was go forth and figure it out on your own. We didn't restrict them at all. We worried about this a little bit, but if it just so happens that Marty Lipton was your great uncle, good for you, right? His team sent an email to the Deal Prof blog saying, we have this problem. They didn't mention it was a competition, and they didn't realize Stephen Davidoff is a very good friend of mine, who immediately said, should I answer this question? And I said, yes, as long as you do it publicly, and then we announced that they had been found out. But they were asking anyone they could for advice. It was quite heartening to see the effort they went through to come up with creative ways of figuring out how to do a better LOI than everybody else. The LOIs were graded. Part of your score in the competition was the LOI. We had a panel of LOI judges who graded the LOIs. The LOIs were shared with all the other teams. As soon as it was done, it was distributed, and then certain LOIs were designated as the markup of choice for each round. The teams came together in Philadelphia for 2 days to do 3 preliminary rounds and then a final round. The way the rounds were organized was 10 minutes you got to sit and confer with your client. The judges, there were 3 judges. One played buyer, one played seller, and these were both lawyers. And then a third was a neutral who was a law professor, which we won't do again, but we were doing that time in order to have some group of people provide me feedback who were in the room. I happened to have a group of law professors there who weren't there with teams, and they functioned as my observers for the event. But next year we won't do that. The clients were told you're supposed to pretend that you're the junior banker. So they have to treat you like a client, but you have no idea what the answer is. Right? Don't make decisions. Do not provide substantive guidance, because I did not want the rounds to be affected by the unfairness of a particularly helpful client or unhelpful client, one way or the other. After those 10 minutes, and really the purpose there was for you to articulate out loud for the benefit of the judge how it is you're about to approach the meeting, and to just get familiar with this particular person who's going to be in the room. They had 75 minutes of interaction between the 2 teams, and then 20 minutes of a wrap-up discussion to deal with the fact that no one was going to finish in 75 minutes. So this was your chance to articulate what would have happened had you had the rest of the day to finish this project. What were you planning to do? Why were you making certain choices in your discussion? We will change that part of this section, part of the round next time. Next time it's going to be a team to judge discussion. It's going to be feedback. It was a mistake this year. And then the judges were given 15 minutes to score. As I said, the judges played seller, played buyer, and then we had the law professor. Where did the judges come from? Well, I think I found a great technique. I found a bunch of partners in law firms who wanted to be sponsors of this event, who wanted to be on the final panel or whatever. And I said, wouldn't this be a great experience for your associates to be involved in? And they tended to agree once they were on the program. But truthfully, the theory was that this is actually a powerful learning experience, to sit in the room and watch others struggle with this challenge. And all the associates, and these were senior associates, 5th through 7th year associates, agreed. And they all want to do it again. Right? And it was an enormous time commitment on their part. They came in the evening and then almost the whole second day, not billing any hours. Of course, they had the cover of it being a partner assignment. On the other hand, they did, in fact, find it to be a very powerful learning experience for themselves. To watch other people struggle with what it is they struggle with was helpful. So they say. The final round. Okay, here I did bring this movie. Oh, sorry. Hopefully this works. All right.
Glad you guys can make it here today, and our client is excited about this possible acquisition today. We hope to move this deal forward. We understand that your client is interested in this as well, as far as focusing in on their core business goals of furthering their motor coach business and generating capital to accomplish that goal. So we hope that mutual interests can further this deal as we discuss logistics today.
Absolutely. I think I'd also reiterate, I think we're excited about moving forward with your client, with you as counsel. We've received a new draft. It looks great. We have a few comments, and I trust you've received that commentary to that. As I'm sure you know, there's a few issues, and we're apart. I think hopefully we can work today to start coming to a middle ground there. In that regard, I think maybe I'll start off by identifying two issues that we saw that were sort of important to us. Looking at this document holistically, I think one of the first things we need to address is construction. We've got an asset sale for you guys proposal for a stock sale. If I can provide some background as to why I think that's a favorable arrangement for both parties. In this sort of dynamic environment, we're really looking to get this transaction done cleanly and effectively and quickly. With that in mind, there's a few advantages to the stock sale being that we don't have to go through that mess of getting authorization to transfer leases, real property and license agreements and things like that, and really hold up the issue once we sign the agreement and start moving forward. Further, from a tax perspective, under an asset sale, we'd be taxed twice, once at the subsidiary level and then once under elimination to our parent company. So a stock sale eliminates that double layer of tax, which is something we very much prefer to have. If you notice from our markup, we provided with the 338 channel election, which provide you with step up basis and obviously important for you as a private equity company. We feel that the way we set this up, it provides a very clean bridge, and if you guys
I'll move on. Sorry. Okay, so I was trying to skip ahead to give you a sense of the other side. Just
slide that out there.
Yeah, sorry.
Is out there at the moment. Was based on focus on taking the assets free and clear.
Sure.
As far as working a stock deal, I don't think our client will be amenable to it. While we do appreciate your concerns there, is there anything that your client would have against, other than these concerns here, against structuring this as an asset deal?
Well, I think so, but let me first address some of these that I mean, maybe didn't go into that detail. I think that in sort of
Let's move a little ahead here.
It's talking identification, but I think from a almost organic standpoint, our client we just don't have to talk stock. And Brett, I guess what I was asking is,
all right, well, I'll stop. I wish we had a little more of a variety. But
that was fine. You don't need any more variety.
see, these are Mark's students, right? And these are Karl's students, and I wanted you to see that they were both tremendously well prepared. I do have to. A lot of why they did such an excellent job is they had excellent coaches, and the other two perhaps left alone a little bit more. I suspect if you saw that, it's pretty good, right? Pretty good. So what happens next is they go through this exercise for for an hour and a half or so, and then they finished. And they actually got to a point where they broke because I think they started to understand the timeline. Then they left. There was a judging process. But then we had the so-called wrap-up session. I think I just want to show you a little bit of that, because I think this is part of the value of the whole thing.
Thank you. Good luck. Hope you're alive and remember.
Okay. So I want to just give. I didn't bring the first part of that because there's a whole technology problem. But this is Henry Nassau, who is the head of the corporate department of Decker. This is Jeff Bodel, who works for Morgan Lewis. Lisa Jacobs, who works for Pepper, and then Michael Sherman, who works for Cozen and O'Connor. And Henry has just had a tirade, right? He's reached over the table and yelled at them, right? That was his contribution to the moment, and it was quite surprising. It wasn't. He hadn't cleared it with me. Right? So it was good.
We know we won when the other side of the across the table. You wouldn't call that either.
So now they're going to do exactly what the students were doing, right? This is their assignment.
Answer you, or answer Earle, or answer me. Look, certainly, we think you are committed to this, and so we don't want you to be disadvantaged. Our host division will only understand anything more. So with that spirit and assuming you are as committed to this as we are, we could see a 90-day
And all of the things working out well, that's an eminently reasonable period of time. We were. Are you putting that
This is about 30 minutes into it, so.
We understand that you're not prepared to proceed unless you have assurances that there's going to be renewal of our existing primary brand license. But again, back along the lines of commitment to the deal, we need to be in a position to know that we're going to go forward with this transaction once we enter into the definitive agreement.
Well, realistically, since the license is one of the most important assets, and our understanding is 80% of the products are sold through that brand, we're trying to migrate away from the brand is substantial. So realistically, it's, one of the conditions to the deal would have to be not only that there's a renewal, but that the licensor approves.
All right, I'll interrupt Michael. So, but you get this idea, right? The students get to try it on their own, they get to feel it, they get to close to the issue, and then they get to watch people who have done it for 30 years do it themselves. That's the one power of the moment in theory. I think for us, they don't look that different, right? I mean, obviously their command of the subject is very different, their facility with it, their willingness to agree to 90 days, for example. No team was able to agree on what the no-shop period was. They just couldn't get to that resolution, right? And the idea that these folks could and weren't calling their client to figure it out is actually part of the difference between students and practicing lawyers. So that was interesting to watch. But the demeanor, the style, the general performance wasn't that radically different. And I think the upshot of it was, I think, this. Let's see if I can get there correctly. Oh, great.
I don't know what we're going to do is waste a lot of time.
There is a recurring.
We think it's important you give us, take
Sales of the other brands. Again, we have to determine what impact that has on EBITDA and consequences.
And that's the question I was asking you, exactly.
Okay.
All right.
I'm sorry, I'm going to run out of this paper. Jeff, this is the punchline, which I managed not to bring with me. The question asked was, okay, give us some reaction to what you saw. And Jeff starts and goes, you guys, you were there. You guys did an excellent job, right? That was his first comment. But then it went beyond that. He said, and they asked each other, could you have done that job when you graduated from law school? And all four of them said, no. Right? That was what amazed them, that this was with their recollection. But then beyond that, because the scoring rubric asked them to compare how the students do relative to their third-year associates, the answer was, at least Lisa was willing to say, several of my second-year associates could not have done the job that I just watched this group of students do. Right? So that was, of course, the highlight for us from the event. I think it was I think, a very successful event. You're supposed to say yes to that also.
Yeah, absolutely. No, I mean, all kidding aside, so we've done a different internal event that involves MBAs that Karl referred to. It's a lot of work, and I just was very impressed with the outcome, and a tribute to Karl is just how smooth the whole weekend went, at least to the outside. I don't know on the inside if you felt like it. If I could mention one thing that I thought was critical to the format, that I thought was a brilliant part of the setup, that I don't think you mentioned, which is what you're looking at in the final round there was the best buyer team and the best seller team after these preliminary rounds matched against one another. And one of the things that we thought was really neat was, and I don't know how your team felt about this, but you essentially would come in as the, just try to resolve it, we were the sellers, okay, so you would initially come in as the seller. You would learn some things that you might not have known from the other side in the process of the negotiation. Then you'd be judged and scored, and the next round would start, and I'm stealing Karl's words, it's like Groundhog Day. So you start over again with the next team, although you start over with a little more knowledge that you might have gotten out of the last negotiation. If you asked the right questions or fell into the right conversation, the other side might have shared some information that they had on their client interview that you didn't know about, that you could then carry into the next negotiation again. So slowly the teams are moving up this learning curve so that by the time they're in their last preliminary negotiation, they know about as much to know. And then they come to the table, you know, the best buyer and best seller team armed with having gone through the exercise 3 times. So that was a neat dimension of it for me.
Yeah, and there are a couple of hidden facts that are meant to drive that process. So student surveys, the student participants, where we surveyed them afterwards, they were very positive, great response. Best thing I did in law school kind of stuff. The National Law Journal wrote a nice article about it, and that was good for my career. The judges who participated in it were uniformly ecstatic about the experience for lots of reasons, largely because they think it's a great way of getting students up the curve. And that notion that, yes, we'll have law graduates who are as good as second-year associates. And then I've had lots of unsolicited interest from students, largely, emailing me, how can we get to do this? So my answer is you have to ask your professors, because students can't ask to do it. Next steps, we are doing it again on March 31st and April 1st in Philadelphia. This time we're going to do 20 teams. And again, I am not going to let teams apply. I'm going to ask individual faculty, do you want to sponsor a team, and will you pick them and tell me who they are? That's the way we're going to do it until we get to the point where we actually have school competitions or regional competitions. And it's first come, first served. So if you think you'd be interested and you'd be interested in sponsoring a team from your school, this is my email address. You'll get information on how to register and pay the fee.
Carol and I want to know if we have an incumbent.
And yes, the first 10 teams have first dibs. Yes, of course. And you guys are guaranteed for life for participating. Any questions? I'm looking for people who want to do this because they think it's a good idea and are willing to help build it up so that at some point it is a regional, intramural, national. I have people from Moscow who would like to do it, so it can be an international competition at some point. And I think it's a way of providing, this experiential thing we've been talking about all week, all last couple of days, in a highly scalable, efficient way, in yet another way, beyond simulation and clinic and so on.
If these kind of deals appear in your curriculum, it was such a fantastic and unique experience. I haven't followed up and told Karl this. I went back and took it to my clinic, and we did it again. We formed teams in the clinic and did it using the hypothetical again.
Washington,
we intend to have an internal competition next year to qualify.
WNL has their transactional law program, and Lyman's not here, but he dovetails it with this. And I actually ran this program this year. This was simulation and similar thing, and we did it with first and second year associates at a law firm as participants, and they love that, right? Because the materials can be reused.
Well, I was a deal lawyer for 25 years before I came to Georgia, and this experience was so incredibly valuable. I just wish I had that. And the fun part for those of us who have been deal lawyers, you get back in deal mode doing this with your students getting so excited and meeting deadlines. And that's really a lot of fun.
Which is what the fun of moot court